I'm Roger Citron, and I'm a professor at Toro Law Center. This is a Toro Law Review podcast, and our guest today is Professor Jorge Roig. He's my colleague here at Toro Law, and I'm delighted that is true, and I'm delighted that he is here with us today. We're going to talk about several First Amendment cases and the relationship between constitutional protections under the First Amendment and emerging technologies or new technologies. So with that introduction, Professor Roig, welcome, and please tell us a little bit about yourself.
Well, first of all, thank you for having me in the podcast today to talk about topics that I think are very, very timely. I just saw a clip from a press conference at the White House regarding the AP, the Associated Press, getting kicked out of one of their briefings for referring to the Gulf of, to the body of water next to Louisiana as the Gulf of Mexico instead of the Gulf of America. So I think these issues are really, really timely. About myself, so I teach constitutional law 1 and 2 at Toro. I've been doing that for about almost 15 years now, both at Toro and at the Charleston School of Law before that. And free speech is one of my main areas of interest and research. So yeah, let's chat.
Well, really, the ball is in your court in the sense that when we talked about doing this podcast, there were a number of Supreme Court decisions from the summer that you had studied and talked about in a number of contexts, including a CLE seminar here at the law school. And then as we were scheduling this, the Supreme Court also decided the TikTok case.
Right.
So we could come at this from the high level, that is understanding what the concerns of the First Amendment are, what the purpose of the First Amendment is, and work our way in or through the cases to understand what the court did in each case. So should we start high and work our way down?
Sure. I mean, there is something about those summer cases that really struck me, and I think it could be a good point to start with. And to be honest, it's more about the way that the oral argument took place particularly in the cases regarding social media sites. So there were a couple of cases that were consolidated before the Supreme Court and were ultimately remanded, for essentially procedural issues, in the sense that the court wanted to develop a much better record before it reached the ultimate substantive issues. And so the opinion doesn't have as much there as was discussed in the litigation and even in the oral argument. And one of the things that really struck me about the discussion during oral argument was that some of the justices, and in that camp would be Alito, Thomas, Gorsuch to some extent, were sort of obsessed with this word censorship. And the case, presents this situation in which you have a privately owned platform, such as Google or Etsy or Facebook or whatnot, that is engaging in content moderation, meaning that it is filtering some of the posts that the individual users, individual citizens and non-citizens alike, are posting on their platform. And so the states of Texas and Florida passed these laws, which are basically demanding that these private platforms do not engage in that kind of content moderation or filtering, or in some cases, when they do it, just have some disclosure requirements about how and why the posts were taken off. And in that context, these justices bring the idea of censorship as if the private platform, was engaging in censorship. But I think, more than just semantics, I think it's problematic to sort of use a word that we have always associated with government action, right? To these private platforms that have a right to speak themselves and to express themselves.
Yeah. And so just to make sure that we're all on the same page, this was the Moody case, I believe, that you're discussing. And the two states in question, I believe, were Florida and Texas.
Correct.
And let's see if we can sort of tease out what you said insofar as, and I think in some ways what you have said in defining censorship and this idea of government action is, I think, a very familiar definition in the First Amendment context. That is, the First Amendment, when it says no law, it's talking about the government, that is, as a regulator or a censor. And so can you tell me, as between you and, say, the justices that you described, where do you disagree, or in terms of, is it just a question of who can censor, that their definition is broader than yours, or is something else going on?
So, I mean, to a certain extent, that's the troubling part, that I'm not sure, right? And so that's why I say, this isn't just about semantics, that you're using a word that I'd rather you use a different word, right? I sense something larger than that, something about the fundamental understanding of what the free speech clause is meant to do, and even more so, what the Bill of Rights, right, and the state action doctrine are meant to do. And what I find, I mean, I have no problem with sort of reassessing those questions, right, and relitigating them to some extent, because certainly it has been a concern for at least 50 years of many of us, including myself. I mean, not 50 years back, obviously, but at least 20 years back, that private entities were consolidating so much power that they were beginning to look like governmental entities, in the sense of having a monopoly of power over the people that they interact with. And so, a wholesale reconsideration of the state action doctrine is not something I'm opposed to. Although, as the years have gone by and sort of my experience and my knowledge has increased, I have become a little more cautious about, arguing for a wholesale rethinking of the state action doctrine. And there are some. I'm originally from Puerto Rico. I did not mention that at the beginning, but there are some examples of this happening in the jurisdiction of Puerto Rico that are interesting and sort of, to some extent, inform my point of view and my willingness to be a little more careful when reconsidering state action. And so if you want, I can talk a little bit about that, or I can keep talking about Murthy.
Yeah, my apologies there. I'm a little trigger happy with the mouse. Can you hear me okay?
Yes.
Okay. And let's actually sort of close or move further with the Moody case, because
Moody. I'm sorry, I said Murthy. That's a different case. Or
oh,
yeah.
And so with Moody, yes, right. Moody is the Florida and Texas laws, and say a little bit, if you can, please, about the holding in the case in terms of why the Supreme Court remanded the case. I guess we should say cases, plural, because it's two different cases filed in two different states. And I wondered the extent to which this conversation we've been having about, possibly reopening something like state action doctrine or fundamental First Amendment jurisprudence questions, is that something that we could see after remand back to the district courts?
Right. So, I think that the final opinion of the court and the majority that really solidified that opinion was very serious in its analysis of what's going on, right? And what I was criticizing of the oral argument and this use of the word censorship is precisely the unseriousness that I thought I saw in their discussion. And what I mean by that is these justices in particular seem to be assuming that anybody that tries to, speak over someone else or silence someone else is a censor. And of course that's not true. I mean, the example I give to my students all the time is dealing with children, right? With your own children. You can tell your children to shut up, right? They don't have a free speech claim against you. And I bring that up as an example of a power imbalance structure anyway, right? And so if you are going to engage in this discussion of should we reconsider state action doctrine because these platforms have so much power, well, you have to analyze with care these issues of power. Are these platforms really monopolizing in the way that government monopolizes the use of violence against its citizens, for example, right? Because the child parent example is another example in which you have one powerful person telling a less powerful person not to speak, but we allow it because, there are all sorts of other considerations that we take into account. And so going back to the majority opinion, what I think they did that was very well done and seriously done is that they realized just how open-ended and how undeveloped the factual record was in this case. And so what they really remand back for is because they're basically saying, Google is one thing, Etsy is a different thing. Personal messages on WhatsApp are a different thing. And this law appears to, or on its face could possibly apply to all of these different things, right? And the First Amendment implications of in each of one of those areas is going to be very different. And so they're sending it back so that factual record is developed. I mean, there's an underlying sort of important procedural thing here, which is that the case was brought as a facial challenge. And so part of what they're saying is this is not a situation that's amenable to a facial challenge because the law is too broad and encompasses way too much activity. And so you have to go back and sort of, do this in smaller as applied chunks, it would seem. Another interesting, I'll stop, but another interesting footnote is that Justice Thomas goes on a long spiel about how he would eliminate facial challenges completely from the face of litigation, which I thought was really interesting, although, it's just one justice, right?
Yes.
So, yeah.
Yes. Let me ask this. Is your sense from the other 6 justices, and that would include the majority, that is, those justices in the majority, sense that we're not prepared to do something as broad or even if you want to use the word radical as sort of reconsider sort of fundamental aspects of state action doctrine and how that interacts with the First Amendment. Is that your sense with respect to the majority?
Yeah, I think the majority is in that boat. And I think Justice Barrett was very, both in her opinion and in the argument, she was very punctilious about this. She was very careful about it. I was very favorably impressed with her approach. And she was one of Kagan and Sotomayor also weighed in, but she was one of the ones that most effectively, I think, brought out this notion of these are very different situations. So, for example, if you're talking about WhatsApp messages, right? You're having conversations with your friends in private. If WhatsApp decided to moderate the content of your conversations in those email chats between private friends, that would implicate the First Amendment much more and much more seriously than if you post a video on YouTube and YouTube takes it down, right? And so I think the majority, those 6 justices probably have a pretty good grasp of these details. Um, I don't, with the others, sometimes I wonder whether they really don't understand what they're saying, or they're kind of playing dumb, right? I mean, there was a long discussion. I think it was Justice Gorsuch about the Section 230 immunity that Congress granted to service providers online back in the 90s. And he kept saying, how are we going to allow these people to be immune? This makes no sense as a policy matter in his head, right? When Congress passed this law, like you don't get to choose what the policy on this issue is. So it really, brought a worry to me about the role of the court as well, right? And the notion that they seem to be wanting to establish a regulatory system for these platforms that is of their liking, as opposed to letting Congress do its job, and letting the free speech clause sort of mediate that, right, in the traditional way that the doctrine has done for many years.
Yeah, that I know we'll come back to the question of Congress's authority and power and the nature of Supreme Court review in the TikTok case.
Right.
Let me.
And the other thing, by the way, is the common carrier doctrine thing, right? That was a huge part of the argument, and I think of the briefing. The opinion, I don't think they even mention it. Maybe they mention it very, very quickly. The majority opinion doesn't really go into that. The concurrences then go in and say, well, why didn't we discuss in more detail this common carrier doctrine, which is really interesting because that really, I mean, in my view, it throws you into the world of antitrust law, right? Which is a different thing, right? I mean, they're related, right? Of course, antitrust seeks to bust power in the private sphere the way that the Bill of Rights and just fundamental rights in general tries to control power in the public sphere. But you can't just, interchange these things without being a little more sophisticated about it. And I think the majority was sophisticated in the sense of leaving that question for another day, right? They realized that is a much bigger question, that this procedural posture and these facts weren't really up to par for.
Yeah, and well, I guess we'll see what happens should the case come back with a more developed record and judicial decisions, because it seems like, with the idea of the common carrier doctrine, it could be a lever into some kind of, regulation that would seem to be disfavored under the First Amendment. And yet, let me sort of ask the question. And so, again, we don't exactly know how this will pan out, but I wonder whether it's, I guess I will ask you for your opinion. That is your view on, is the idea here that instead of some sort of unified theory of the First Amendment and communications technologies, if we call them that in fact we may be, that maybe where we should be headed, and perhaps where we may be headed, is something like sort of almost subspecialties or more specifically defined sort of rules, regulation. One thing you said led me to, in terms of where we should be headed and where we might be headed, is instead of a sort of unified theory of the First Amendment that, broadly distinguishes between private actors and government actors, is the idea that in fact there may be, a different understanding or application of the law depending upon the nature of the technology, who's using it, and for what purpose. That is, could it be the case that we end up, in fact, with something like, oh, private communications, there's one body of law, and platforms where content is posted publicly, that we might end up with a different legal regime for that type of platform or technology.
Right. And I mean, to a certain extent, we have that in the doctrine, in the sense of that's how the court has handled, the difference between newspapers and AT&T wireless communications, right, or wired communications. So the traditional sort of distinction has been, well, are you just providing the infrastructure, the tubes, as they say sometimes, or the pipes through which the information goes without touching the information? Or are you more like a newspaper that engages in editorial control? And to a certain extent, that's what the court did in this case. It's sort of laid out that doctrine for the Court of Appeals, because they were really concerned with the approach that the Fifth Circuit had taken, particularly, which again was part of this zeitgeist of declaring, private censorship a thing, right? And that's kind of what bothers me, because it's, this doctrine has been around for a long time. It's been developed. We've thought about these problems. This is not as much a question of first impression as some people make it out to be, I think. It takes me back to the days of the 90s when cyber law was becoming a thing, and the famous Frank Easterbrook essay on the law of the horse, right? And his point, which I think was well taken, even though I think it had its limitations, was that, it's not that new. We have law for all these things. We just need to implement this law and maybe tweak it a little bit, to the extent that we might want to create a more structured system of different rules, like you were describing. My first sort of response would be, well, that sounds more like a legislative task than a judicial task, right? And going back to the antitrust issue, even though antitrust law is not exclusively federal, right? States can have their own bits of antitrust law. It strikes me as the kind of problem that is national and that should have a uniform type of regulation. So that's another thing to consider, like who should be making those rules, right? And I think that the courts are probably the worst suited to doing that. To the extent that they have already had to do it, well, fine, keep using that doctrine, right? The newspaper cases and all that stuff. But to the extent that we think this is a truly unique problem, well, then Congress should do something about it, like they did with Section 230 immunity, right? And so this attitude of the court of saying, oh, I don't like Section 230 immunity, so I'm going to find a way to kick it out, that, I don't think that's appropriate in any way.
I think the through line here to the TikTok case really is congressional action, legislation that seems to have been specific, clear, and resulted in a pretty straightforward decision by the Supreme Court. Can you just tell us a little bit about the case, and then we can talk about, what the court, did correctly, or what going forward we could learn from the court's decision in this case?
Right. So the TikTok case arises out of an act of Congress, right? So TikTok is this company that, as companies do, has multiple subsidiaries, right? And some of those corporations are U.S. corporations, but they're all ultimately owned by a Chinese entity that lives under Chinese law, which I know very little about, but from the case we can learn that the Chinese government has certain powers over these corporate entities. I mean, one of the things that strikes me as interesting, to be honest, is as if the federal government, the U.S. government doesn't have power over corporations, right? I mean, sure, the Chinese can ask for information from what is it called, ByteDance. But you're gonna tell me that if the CIA goes into Google, they're not gonna get whatever they want, right? So there's a bit of a double standard there that I think is interesting, and sort of an assumption that our government won't hurt us, right? But the Chinese will, anyway, or the French government or the Canadian government, right, or any other government that can solicit this information from every other company.
I feel like we may be verging into national security law now. And that's relevant, but
anyway, let me go back to the facts, right? So anyway, there's a concern that all of the information that TikTok is compiling about U.S. citizens when they use the platform and share, their contact lists and whatnot with the platform, that all of that information is going to be accessible to the Chinese government, and that the Chinese government may use it for purposes that compromise our national security. And so Congress passes a law basically saying, TikTok, you're not going to be able to do any more business with anybody in the United States, and anybody in the United States that does business with you is going to be subjected to these very severe penalties, unless and until you divest your corporate structure in such a way that the Chinese government is no longer has these powers as judged by the president of the United States. And so a series of users of TikTok, as well as the corporate entities themselves, file a suit saying that violates the freedom of speech. So that's kind of the setup of the case. The court resolves that such a statute is a content-neutral regulation of speech. So they recognize that there are speech interests that are being compromised in this whole process, but they decide that this is not content-based, that it is content-neutral, and therefore applies intermediate scrutiny and find that it passes intermediate scrutiny.
And to me, the case seems as straightforward as you've described it. Do you agree with the decision? Do you agree with the analysis? Is there more to it than perhaps meets the eye, or more to it than is indicated in your summary?
Yeah. So I have a series of concerns with the opinion. Of course, unanimous opinion, which we hardly ever see anymore, but I'm going to disagree with the unanimous court anyway. No, I mean, it's a bit of a pet peeve in a sense. This whole issue of content-based and content-neutral and the distinction has been, in my view, problematic for decades, right? Starting at least back with the exotic dancing cases. So back in the 80s, there were these cases in which the court says, you have a zoning ordinance that says that these exotic dancing venues, striptease clubs, right, are not allowed in certain areas of a town. And the court says that is a content-neutral restriction. And that always struck me as, just kind of ridiculous, to be honest. Like, you are targeting one specific type of dancing, one specific type of expression, and treating it differently from everything else. How is that not content-based, right? And the same, and that's where the secondary effects doctrine comes in. And I see something very similar happening here, right? You are saying, I am targeting one medium of communication and completely taking it out, right, of the public's hands, of the U.S. citizens' hands, because I'm not concerned with the messages that people are posting on TikTok, but I'm concerned with these secondary effects. They don't use that terminology, but it's very similar analysis, right, of how the Chinese government is going to use that information. One of the things that I find troubling is that everything we're talking about is information, right? So is it really a secondary effect? It's not really secondary to speech. It's still a speech concern about how you handle information. So my problem is mainly with that. Not the national security issue is a separate one, and I can get into a pet peeve about that too. But that one's, I would say, is a bit of a stronger argument, right? I would be much more comfortable with this opinion if they had applied strict scrutiny and held that the national security concern passed strict scrutiny. This playing with what is content-based and what is content-neutral, which has been a continuous problem, in my view, with the court's doctrine, is something that I find problematic. And I think that this is just another example of them just, instead of facing head-on the strict scrutiny issue, they come up with some other, contradictory distinction between content that counts and content that doesn't count, kind of thing, right?
Yeah, and it's interesting. I think that in my defense, in the simple approach, if I can call it that, I'd say that part of that for me was rooted in, well, you invoke national security and you have Congress legislating to protect the national security interest. To me, it seems like, no challenge is going to get past that.
And that's my issue with the national security piece.
Well, go when I've opened the door.
That it's through it. It seems like it's becoming this shibboleth, right? That you put up national security and everything falls away.
We were discussing the national security interest cited by Congress and discussed in the court's decision as one reason for upholding the law. And I believe you were talking about that.
Yes. So the national security pet peeve, if you will, is I find that there have been a series of cases in which the court is sort of accepting this national security issue as a sort of shibboleth, and as soon as the government just raises the national security issue, the standard of review goes down. The way that the court analyzes it becomes much more lenient, and I'm thinking specifically of Trump v. Hawaii, the case about the so-called Muslim ban, in which the court, the pet peeve is really strong with that case, right? Because they then, after they do what the national security shibboleth thing, as I'm calling it, they go on to then allegedly overrule Korematsu, which is like the ultimate example of exactly that kind of conduct, right? So in Korematsu, the court says, oh, the president has told us that we have an espionage and sabotage problem in California, so we're just going to let them do what they will, and we give deference to the military, even though we're just being screwed for the first time. And the irony in all of this is just overwhelming. And then you have a case, 50, 60 years later, more than that, right? 70 years later, in which you have a president specifically saying, right, what the illegitimate interest of the law is for months and months and months. And then when the administration just changes that and says, oh, no, this is actually about national security, the court just takes it for good, just as it did in Korematsu. And in this TikTok case, we see something that's maybe not as crude, but it is nevertheless similar. So is there any evidence that the court discusses of China actually engaging in any of this objectionable behavior of spying or utilizing disinformation for evil purposes? No. And what's even more curious is that, in the context of Korematsu and all that history, is the U.S. government, actually, administration submitted some secret evidence, as they call it, and the court refuses to consider it. And now the reason why they refuse to consider it is very reasonable, right? They say, well, the other party hasn't seen this evidence. This is ex parte. It's inappropriate procedurally. But of course, there are ways of fixing that, right? You could just, order that they share the information, or if it is actually so delicate that it can't be shared with the other party, you have in-camera review, as the Supreme Court, expressed in U.S. v. Nixon in great detail. So it's almost like they're putting blinders on themselves and saying, oh no, we're just going to assume that what the government says is true and roll with it. And that strikes me as Korematsu and Trump v. Hawaii all over again.
Let me ask, again, in trying to, defend the simplicity of my response, which is what Congress did order. That is to say, you can still keep TikTok, you can divest. Does that do anything to, mitigate the concerns you're describing, or bring congressional action within the First Amendment? That is, it's not directly prior restraint or censorship in the sense that there is a way to cure that isn't content-based.
Right. So a couple of things there. One of them is certainly the fact that it's Congress doing it as opposed to an executive order in the other cases that I mentioned is something that should alleviate some concerns, right? So this went through the democratic process and it's subject to the democratic process, and the next Congress can overrule it. So in that sense, it's a little bit more comforting. The other point about, it's not directly targeting the content or the information, it is rather targeting the ownership of the company. Yes, I think that would alleviate to some extent some of the concerns. The problem is that the remedy is so overpowering, right? There's hundreds of millions of people on this platform that make a living out of it, that, and all kinds of other things. And you are completely eliminating that whole medium of communication. That strikes me as deserving of more consideration than just saying, oh, it's just about the owner, right? The other thing is that I don't know that it's really consistent with precedent. So, consider Citizens United, right? Because at the beginning they say, oh, this is, just a corporate control thing. This is about, corporate regulation, not really about speech. Well, wasn't that the case in Citizens United as well, right? And of course, in Citizens United, the corporate entities receive 100% or more protection. It makes me think also of the Son of Sam case back in the late 70s, early 80s, when the state of New York passed a law saying this serial killer who was writing a book about the people he killed should not receive the proceeds from the book. And the court allowed it after passing strict scrutiny, right? But the court was very clear that this requires the full free speech analysis because it is an infringement. So the idea that, oh, we're letting you speak, we're just taking the money away from you. Well, the court in the past has said that's a problem too. The other thing about Citizens United that I think is very on point is this idea that targeting a particular speaker and trying to make distinctions between different types of speakers is anathema to the free speech clause, and they're very, very, very strongly worded doctrine created in Citizens United about that, and now all of a sudden it doesn't matter, right? Now, behind all this is the fact that this is a foreign company, or I should say that the ultimate owner of these companies is a foreign entity, which leads to another little thing that I find troubling, which is there's a part in the opinion in which they say something to the effect that persons and corporations, people, individuals and corporations who are foreign are not protected by the free speech clause, which struck me as odd, right? Because again, haven't we been talking about the Bill of Rights applying to persons and not citizens? And again, I've seen several opinions in the past few years in which the court seems to say, no, if you're a foreign citizen, you're not a person for purposes of due process, or you're not a person now for purposes of free speech, or you don't have a free speech interest. And so I see a lot of confusion and inconsistencies in a lot of these cases.
Let me very, perhaps very briefly, but I think you alluded to earlier when we were talking about the Florida and Texas, the Moody case, the Murthy case,
Right.
which is involved a case that came up through Missouri, I believe, or involved in Missouri law, and it was a case that was resolved on standing grounds. Does Murthy add anything to what we've talked about so far, or is it, look for it in your standing section of your con law casebook? Don't look for it in the First Amendment section.
Yeah, I think as a standing case, it's a good case. And unfortunately, yeah, I don't think it adds very much to the free speech substance discussion. However, the fact pattern and and the litigation in general, the arguments that were being made and whatnot, I think are very relevant and are due to come up again very soon. And so the little comment I started with about the White House press conference got me thinking about that case too quite a bit, because so the issue in that case is that the Biden administration was having communications with some of these social media platforms, Google, Facebook, etc., regarding misinformation in those platforms. I was basically asking these companies, please try to handle that misinformation and either label it as such or take it off your site or whatever, do some content moderation. And so the question was whether that was government pressure that would violate the free speech clause. And again, there are cases about this in the past, right, having to do with lists of objectionable books and lists of objectionable movies and whatnot. I think that's an interesting issue. And I think it's going to require some line drawing that is going to be very hard to do in terms of, how much can an administration communicate with these platforms before it crosses a line into inappropriate government pressure. I find a little irony in the idea that the Biden administration is being accused of violating free speech by talking to Google. But if Congress comes in and bans a whole medium of communication, that is somehow not government pressure, right? I mean,
right.
Of course, again, the Biden administration is the U.S., this is China, but there should be some consistency, right? There should be some overarching theory here, and I'm struggling to see it.
So maybe as a closing point, and let's see if I can ask the question in a helpful way, which is that,
and I'm sorry, because I forgot about the AP White House press conference, right? You have the White House press person telling AP, you're not allowed in my conference room unless you call the Gulf of America. Now that's government pressure, right? I mean, and not just pressure, you're punishing them. You're kicking them out of the White House.
For editorial reasons, right? For editorial reasons, just
the word that you chose, literally, right? And so that level of inconsistency is striking and troubling, and to the extent that the court just thinks this is business as usual, it's just attorneys making their argument. I think we're well past that point, and people continue to refuse to acknowledge that the system has broken,
Well, that may be where I was headed, insofar as I think, in the first half or so of our discussion, one idea, and I think it's a real theme, certainly in the First Amendment context, is there's really nothing new under the sun. That is, we all understand that technology evolves. So that means, in particular, communications technology evolves. And yet, the basic principles are well established, and it's just a matter of application and sorting out how they apply in new contexts. And so that's one, sort of point or approach that we've discussed. But you also say, and in each of these cases, you've talked about tensions, inconsistencies, and so on. And I wonder whether it's also the case that, along with this framework that we have, that the concerns that we have, these tensions, contradictions, inconsistencies, they're built in as well too. And so, we do have a framework, we do have an approach, and yet it's imperfect, to say the least. And how do we get it right? That is that the most pressing question for the court going forward? As whether it's these cases or the next ones that come up in the context of the First Amendment and technology and so on, as they come to the court.
Yeah, certainly, right. There are certainly all manner of inconsistencies in the doctrine as it stood in 1980 and as it stands now. I guess, what we should try to do is not make it worse, right? And so going back to one of my first points about censorship, I think if you, start using what has been, I would say, at least partially a term of art for many years in a way that is fundamentally different from the way it's been used, you're not contributing to a uniform body of law. You're doing the opposite. And, thinking again about Easterbrook and the law of the horse and cyber law and sort of the way we were thinking back in the 90s, I see an opening in this argument that new technology requires new law or new ways of looking at things. I see an opening for misusing that idea to start a revolution, so to speak, in small r, if you will, in the sense of make that a justification for the wholesale reimagining of the law, right? So just to fit whatever personal preferences you have. And I think back in the 90s, because a lot of us, right, I was a young guy in the 90s, we were super gung-ho about the internet. We thought this is going to change the world. We can rebuild the world in a different way, right? That was a lot of that sort of utopian mentality. And I can see the same kind of idea happening on the other side now. And at the end of the day, saying that you need new law because there's new technology ends up being an excuse to make new law, when really maybe the change that you need is not that dramatic. It's just some tweaks. So I just thought of that right now as I was sort of thinking back to our attitudes in the 90s, and how I can imagine people feeling the same way now in terms of controlling the Facebooks and the Googles of the world.
All right. Well, let's end there. One thing I think is safe to say is that we'll be back at it again, because, of course, in the first case, there was a remand, and who knows what the case will look like when it comes back. So thank you so much for taking the time to speak with me and for this podcast. Thank you.
Thank you. It's always super fun to discuss these things with you, Roger. And by the way, don't feel bad about, your approach to the TikTok case. It was unanimous. All 9 justices agree that it's a simple case. I'm the one who's wrong here.
Well, I don't know. This may or may not make it into the final version, but I had a tax professor who said, obviously, if it's a unanimous opinion, it can't be right. So you would have picked up his vote.
Right. Well, thank you so much, Rod.